datang di Universitas Muhammadiyah Purwokerto. Kita mulai dari gedung rektorat. Gedung rektorat ini biasanya mengurusi segala sesuatu dan urusan yang menyangkut Universitas Muhammadiyah Purwokerto. UMP ini punya banyak banget pilihan prodi yang bisa kalian pilih. Jadi UMP punya 11 fakultas, program pasca sarjana, program profesi buat guru, apoteker, dan juga program buat nurse. Dan yang perlu kalian tahu, UMP ini adalah kampus swasta terbesar di Jawa Tengah bagian barat. UMP ini berdiri sejak 5 April 1965. Jadi udah banyak banget alumni yang tersebar di dalam maupun luar negeri. Kalian suka nongkrong atau kalian orangnya suka ngopi, tenang. Di UMP ini ada gedung penerimaan mahasiswa baru yang emang didesain ala kafe. Jadi di sini tuh kopinya enak-enak. Dan kalau kalian mahasiswa baru di sini, pasti suka banget tempat ini. Buat kalian yang suka foto-foto, UMP has the answer. Jadi air mancur ini adalah spot terbaik buat kalian foto-foto kalau kalian jadi mahasiswa baru atau kalian wisuda. Jadi ini adalah komplek gazebo dari UMP. Di sini kalian bisa nyantui atau berteduh, atau kalian bisa menikmati fasilitas internet yang super cepat. Jadi ini adalah lapangan basketnya UMP. Selain itu kalian bisa main bola atau kalian main tenis dan kalian juga bisa jogging. Di belakangku ini adalah Masjid Kiai Haji Ahmad Dahlan. Jadi buat kalian yang belum tahu Kiai Haji Ahmad Dahlan itu siapa, beliau adalah pendiri dari Muhammadiyah. Makanya UMP mengabadikan nama beliau menjadi nama masjid ini. Dan buat kalian yang suka diskusi, di sini juga disediakan tempat untuk diskusi. Dan kalau malam, ini masjid keren banget karena ada cahaya-cahaya lampu yang bikin masjid ini tambah megah. Kalian penasaran nggak dengan gedung tertinggi di Purwokerto? Ini adalah UMP Tower atau Gedung Kiai Haji A.R. Fahrudin. Yang dimana di dalam gedung itu banyak banget fasilitas yang menunjang kegiatan akademik di UMP. Kalau kamu pengen jadi dokter, UMP ini punya fasilitas laboratorium yang lengkap dan nyaman. Dan kalian gak usah khawatir karena ditunjang dengan tenaga pendidik yang profesional. Areal seluas 5 hektar dengan pemandangan yang asri. Ini adalah kompleks Science Techno. Jadi di sini tuh ada kafe, ada asrama unggulan, ada masjid, ada research center, dan yang unik di sini ada kebun kelapa kopior. Kalau ngomongin kebun kelapa yang di UMP, ini adalah Coconut Research Centernya UMP yang khusus meneliti tentang kelapa kopior dan plasma nutfanya. Dan gak main-main, untuk meneliti kelapa kopior ini berkolaborasi dengan SIRAT dari Prancis dan juga University of Queensland dari Australia. Wow, ini keren banget desain cuy. Jadi pengen makan kopior. Ini adalah asrama unggulan UMP. Selayaknya asrama, kalian bisa istirahat, kalian bisa belajar, dan di sini juga ada program-program unggulan seperti tahfidz, belajar bahasa Inggris, bahasa Arab, dan kalian juga bisa belajar leadership dan entrepreneur. Jadi itu tadi kampus tour Universitas Muhammadiyah Purwokerto. Dan buat kalian yang punya rekomendasi kampus mana yang harus aku jelajahi, silahkan komen di bawah. Dan juga buat kalian jangan lupa like, komen.
Cek. So dear all participants, we're about to start the international seminar. So how you can be quiet, please. Bismillahirrahmanirrahim. Innal hamdalillah nahmaduhu wa nasta'inuhu wa nastaghfiruhu wa na'udzubillahi min syururi anfusina wa min sayyiati a'malina may yahdihillahu fala mudhillalah wa may yudlil fala hadiyalah. Wa asyhadu an la ilaha illallah wahdahu la syarikalah wa asyhadu anna Muhammadan abduhu wa rasuluh. Assalamualaikum warahmatullahi wabarakatuh. Good morning, selamat pagi, guten Morgen, ladies and gentlemen. Welcome to the international seminar held by Faculty of Law, Universitas Muhammadiyah Purwokerto, with the theme Judicial Review Policy, a Comparison of Laws in Indonesia, Germany, and Malaysia, 14 February 2023. The Honorable the Regent of Banyumas Regency, or the representative, the invited guests from District Attorney, District Courts, Religious Courts, Police Resorts, our beloved neighborhood universities and Faculty of Law, the notaries, Daily Board of Trustees of UMP, the Rector, Associate Professor Dr. Jebulu Suroso, and the Vice Rectors, Dean of Faculty of Law UMP, Dr. Sudiro, the Chairperson of the International Seminar, Mr. Lutfi, Director of International Affairs Office, the committees, and our dear participants, ladies and gentlemen. And let me greet and welcome the speakers of today's agenda, Professor Smith from University of George August Göttingen, Germany. Welcome to Universitas Muhammadiyah Purwokerto, Prof. Hello. Dr. Nur Fajri Ismail from University Science Islam Malaysia. I hope you already joined us through Zoom meeting platform. And Ibu Indrianti from Universitas Muhammadiyah Purwokerto. Also the moderators, Mr. Novan and Mr. Mahdi from the International Affairs Office, Universitas Muhammadiyah Purwokerto.
Ladies and gentlemen, let's thank to Allah Subhanahu wa Ta'ala for His blessing so we can meet together in these very great occasions. Salawat and salam for our Prophet Muhammad sallallahu alaihi wasallam, who has brought us from the darkness to the brightness. Before we start the agenda, let me invite Miss Indi for Quran recitations, please.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasy syaithanir rajim. Bismillahirrahmanirrahim. Inna hadzal Qur'ana yahdi lillati hiya aqwam wa yubashshirul mu'minin الذين يعملون الصالحات الذين يعملون الصالحات أن لهم أجرا كبيرا وأن الذين لا يؤمنون بالآخرة أعتدنا لهم عذابا أليما ويدعو الإنسان بالشر دعاءه بالخير وكان الإنسان عجولا صدق الله العظيم. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Miss Indi. My God's bless be upon us. Distinguished participants, let us sing the national anthem of Indonesia, Indonesia Raya, Then will be followed by Muhammadiyah song Sang Surya. To all participants, please stand up. To all participants, please be seated. The next agenda, let us hear the speech from the Dean, Faculty of Law, Universitas Muhammadiyah Purwokerto, Dr. Sudiro. Time is yours, sir.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Rector of Universitas Muhammadiyah Purwokerto, Associate Professor Dr. Jebul Suroso, along with the Board of Executive, the Head of BPHUMP, along with the Board of Members, the Forkompinda, Official of Banyumas Regency, the Head of Agencies, our colleagues, invited guests, and all of the participants of international seminar in the Faculty of Law, Universitas Muhammadiyah Purwokerto. First of all, let's send our gratitude toward Allah, the Almighty, for the countless blessing and opportunity so we are able to gather in this academic event. In this occasion, we would like to express my highest appreciation to Professor Thomas Smith from George August University, Germany, Dr. Nur Fajri Ismail from Universitas Sains Islam Malaysia, who will presenting in the seminar online, and Associate Professor Dr. Indriati Amarini from Universitas Muhammadiyah Purwokerto. Our honorable speaker would discuss about the judicial review policy in Germany, Malaysia, and Indonesia. We are hoping, especially for the students who are attending in this event, will be able to gain knowledge in order to increase human resources ability as the future jurists. Also for us, we are hoping that this international seminar will give new insight in the theme of it, namely comparative study about judicial review policy is an extremely interesting issue. Not to forget, we would like to express our condolences for the loss of Dr. Nur Fajri's mother-in-law. May Allah bless her and give her the highest place in heaven. Amen. Last but not least, we would like to thank everyone who is involved in this moment, especially the academic society of the Faculty of Law, Universitas Muhammadiyah Purwokerto. Let's enjoy the seminar. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, sir.
Distinguished participant, to officially open the International Seminar on Judicial Review Policy, a comparison of laws in Indonesia, Germany, and Malaysia, let me invite Associate Professor Dr. Jebul Suroso, Director of Universitas Muhammadiyah Purwokerto. Time is yours, Bapak.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning everyone. Selamat pagi, salam sehat untuk kita semua. Alhamdulillahirabbil alamin. Shalatu wassalamu ala nabiyyina Muhammadin wa ala alihi wa sahbihi ajma'in, amma ba'du. Ladies and gentlemen, first of all, I like to thank to Allah our God for blessing us so we can gather in this international seminar today. Salawat and salam so always send to our beloved Prophet Muhammad sallallahu alaihi wasallam. So today it is my pleasure to welcome you all to this international seminar with the main theme Judicial Review Policy, a comparison of law in Indonesia, Malaysia, and Germany. And then that is organized by Faculty of Law, Universitas Muhammadiyah Purwokerto. The first big thank and very appreciate to Faculty of Law, to Dean, member of faculty, and all committee for make this agenda and international seminar today can happen. I also like to especially thank to Professor Dr. Thomas from the University George August Göttingen, Germany, Dr. Nur Fajri Ismail from University Sains Islam Malaysia, and Ibu Indriati, Dr. Indriati Amarini from UMP for being able to be our speakers in this international seminar. So ladies and gentlemen, I believe during this seminar we will learn and discuss very good issues related to judicial review policies in the 3 different countries, Indonesia, Malaysia, and Germany. And then the speakers who are going to share their ideas at the seminar are the expert at this field. So this is very good opportunity to learn and get new insight from their expertise. This international seminar is very good event, especially our effort to engage the global community. So UMP believes that such program is also important as way to enhance our relationship with all our potential partner. For our information, currently UMP has done many international program with our partner around the globe, and we hope that we can always work hand in hand with our partner and develop more collaboration in this future. So inshallah, UMP is well recognized university in Indonesia, and now we are committed to be an internationally reputable university. Therefore, we invite more professor and international students from our partner universities to study or to exchange program at the UMP in order to experience good academic and social life, especially under umbrella Merdeka Belajar Kampus Merdeka. And then, on behalf of Rektor Universitas Muhammadiyah Purwokerto, I officially open this international seminar today with saying Bismillah together. Bismillahirrahmanirrahim. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much to the Rector. Ladies and gentlemen, International Seminar on Judicial Review Policy, Comparison of Laws in Indonesia, Germany, and Malaysia has been officially opened by the Rector of UMP. Before we're coming to the main agenda, the presentation, let me invite the regent of Regency Banyumas, or the representative, the speakers, rector, vice rectors, the dean and vice dean, the director of International Affairs Office, the committees to come forward to the stage to capture the moments and for token giving session. So please. I'm inviting all the committees to come forward to the stage to take the picture together with the speakers and also the executive. Foto bersama dulu Bapak. I'm inviting the committees from Faculty of Law, UMP, to come forward to take the picture. Bapak Gamalel and also the Bapak Slamet Widodo, please come forward, Bapak. Bapak Gamalil, come join us, Pak. Thank you so much. And Bapak Rektor, would you please to stay over there, and then I'm inviting Mbak Dian to give the token, and then the Rector will give the token to Professor Smith. Please wait for a moment. So Professor, can you please come forward to here, and then, okay. Yeah, the Dean of Faculty of Law may accompany the Rector and also Professor Smith to take the pictures together. Bapak Dekan bisa maju ke depan, Bapak. Also the Chairperson of the International Seminar, thank you. Thank you. Thank you so much, Bapak. Thank you. All right, so distinguished participants, ladies and gentlemen, it's time for us to go to the main agenda of the international seminar. To lead the session, let me invite the moderator, Mr. Novan. Time is yours, Mr. Novan.
Thank you, the Master of Ceremony. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. How are you? Alhamdulillah. I hope we're all in a good condition so that we can join this international seminar from the beginning to the end. And welcome, Prof. Smith from Germany and from Yogyakarta to Purwokerto. It's a lovely city. Hopefully you can enjoy the rest of your stay here in Purwokerto until Wednesday, if I'm mistaken. Yeah. Okay. The Honorable Dean of Faculty of Law, Universitas Muhammadiyah Purwokerto, and then the Honorable Speakers of this international seminar, which entitled Judicial Review Policy, a comparison of laws in Germany, Malaysia, and Indonesia. Distinguished guests, ladies and gentlemen. First of all, let me introduce myself. I am Novan Andrianto from the International Office, and I'm really honored to be the moderator of this session. And I'm very pleased to welcome you all to this offline international seminar. After 2.5 years of pandemic, we've been doing everything online, but this year, finally, UMP can, inshallah, successfully do the offline international seminar with Professor Thomas Smith with us here in UMP. All right, so in this seminar, we have invited 3 great speakers from 3 different countries. The first speaker will be Dr. Nur Fajri Ismail from University Sains Islam Malaysia. and he will be delivering the presentation online through Zoom application. Maybe I should greet Dr. Ismail. Assalamualaikum, Dr. Ismail. Can you hear my voice clearly, Doctor?
Waalaikumsalam. Yes, I can hear you. Can you hear me?
Okay, we can hear your voice clearly, Doctor.
Thank you.
All right. Thank you. And the second speaker will be Professor Thomas Smith from the University of Göttingen, Germany. And the last speaker will be Dr. Indriati Amarini from our beloved university, Universitas Muhammadiyah Purwokerto. All right, for your information, this international seminar will be organized in hybrid mode, meaning that the first speaker will be talking online there from Malaysia, and the two other speakers will be presenting the material in this venue with us offline. Okay. All right. Before we begin, may I briefly introduce our first speaker, Dr. Nur Fajri Ismail from University Sains Islam Malaysia, who will be delivering the material online. All right. So Dr. Nur Fajri Ismail is well diverse in areas of laws of criminal and civil laws for more than 14 years. He is currently teaching at the Faculty of Sharia and Law, University Sains Islam Malaysia, as a senior lecturer in dispute resolution and administration of justice. He was with advocate and solicitor with ASMI and Associate in Kuala Lumpur as senior associate in litigation and dispute resolution practice group. Prior to that, he served as judicial officer handling both civil and criminal cases. Dr. Nur Fajri was attached with Greater Manchester Crown Court, United Kingdom in 2009 to understudy the judicial and coroner's practices. He graduated from National University of Malaysia or University Kebangsaan Malaysia in Bachelor of Laws in 2004 and Master of Laws in 2008. He then pursued his doctoral degree and graduated in Doctorate of Law on the Administration of Criminal Justice from University of Malaya, Malaysia in 2018. He was called to the Malaysian bar in 2008. In dispute resolution practice area, Dr. Nur Fajri is an accredited construction adjudicator and panel of adjudicators of AIAC since 2014. He attended postgraduate diploma program in commercial arbitration organized by Chartered Institute of Arbitration, Australia. He was involved in teaching, research, and conduct training in the subject of alternative dispute resolution at Universitas Kebangsaan Malaysia and University Technology Malaysia, and also towards Contractors Division of Construction Industry Development Board of Malaysia. Dr. Nur Fajri has authored, co-authored, and edited various articles on criminal justice, dispute resolution in construction industry, and he was previously member of the editorial board of Construction Industry Development Board of Malaysia, Construction Law Report 2020, edition 2021. Meanwhile, his area of specialization is on the criminal justice and procedure, alternative dispute resolution, and judicial system of justice. All right, so that's the brief CV of our first speaker. If then I need to read all of the CV, it will take more than an hour, I guess. So I have summarized the main things about Dr. Nur Fajri. And before we begin, once again, I'd like to check if the voice of Dr. Fajri is clearly sound in this venue. Dr. Fajri, are you ready to present your material?
Yes, inshallah.
All right. So, furthermore, before we listen to Dr. Fajri's presentation, then let me tell you a brief rules of this presentation. Dr. Nur Fajri will have around 35 minutes for the presentation session, and then will be continued directly with the question and answer sessions. So, if audiences you have questions, then you can prepare both in English or Indonesia. If you find it difficult to deliver in English, then you can tell me in Bahasa Indonesia, then I will assist you to translate into English. And I believe Dr. Nur Fajri boleh paham bahasa Indonesia ya, Dokter?
Boleh, boleh.
Oke, jadi boleh bertanya dalam bahasa Indonesia. Baik, without further ado, I will let Dr. Nur Fajri to start his presentation. Dr. Fajri, the time is yours.
Baik, Bismillahirrahmanirrahim. Alhamdulillahirrabbilalamin. Wassalatu wassalamu ala asyrafil anbiya wal mursalin. Sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Thank you, Mr. Novan, for me that is quite comprehensive CV for a brief introduction. To Professor Thomas as well as Dr. Indriyati. Yeah. First and foremost, I'd like to apologize. It's been quite a long week for me and my family. Allah is the best planner, but thank you UMP for the warm invitation, and I hope that you can hear me clearly. Is it? You guys can hear me? Can you guys hear me?
Yes, your voice is very clear, Doctor.
Thank you very much. All right, okay. I think I would like to start my presentation. My title would be the Judicial Review Policy in Malaysia. But before that, next slide. Thank you again to the organizing committee for having me this morning. I know this is not the first time for Professor Thomas in Indonesia, but this is the first time that I'll actually visit UMP, although it is a virtual presentation. Next slide, please. Next slide. All right. Pertaining to my topic, right? Judicial review policy in Malaysia. So judicial review, it is some sort like a remedies here in Malaysia, because normally as a general principle, when the person feel aggrieved at the hand of the administration or in the hand of anyone, right? Then due to the fact that because of the infringement of any of his right or deprivation of any of his interests, therefore, of course, he wants a remedy against the administration for vindication of his rights and redressal of his grievances, right? So for today, I'm going to discuss the judicial review policy in two aspects. Yeah? The first aspect is under the administrative law, and the second aspect is under the criminal justice aspect, right? Under the administrative law, the judicial review in Malaysia considered to be a judicial device in which the court, it is some sort like a judicial control over the administrative action as a part from the statutory judicial remedy, right? Of course, I believe that same like Indonesia, you guys have the law that provide for the remedies as well as the any other avenues which lays out in the rules and regulation. Same in Malaysia, judicial review can be viewed as the inherent jurisdiction of the court, right? Because normally statutory judicial remedy, they have a specific provision of law, but for the judicial review, it is considered to be an inherent jurisdiction, yeah? Apart from territorial, apart from any jurisdiction to punish or to hear cases, for example, inherent jurisdiction can be considered to be an additional powers, right? It has been decided in Malaysia, in one of the highest court in Malaysia. Judicial review can be known as the additional powers, that is to say powers in addition to those already seized off by that court, right? So that is one of the important aspect, right? So what is inherent jurisdiction? Inherent jurisdiction in Malaysia considered to be one of the judicial mechanism as to control, as I mentioned to you, to control over any administrative action, as to prevent any harm and injustice that has occurred by the decision of the administrative action of the government, for example, right? So we have one of the case here, Indira Gandhi, which being considered to be the high profile case, right, in Malaysia. So inherent jurisdiction considered to be one of the important mechanism as to prevent harm and injustice, right? Next slide. Next slide, please. Okay, I mentioned to you that judicial review is one of the judicial mechanism, judicial device mechanism. Therefore, in administrative law, for example, judicial review plays a significant role, right, to the parliamentary system. Because I believe that in administrative law, if you learn that in theory, government is accountable to the parliament, right? We have a separation of power principle, government, parliament to make law, government to implement the policy, and the court actually to interpret the law, right? But however, in practice, if we realize that there are two major issues. The first would be the parliamentary supervision over the government. Sorry, spelling error over there. Parliamentary supervision over the government is not effective so far, right? And the government is only accountable to parliament only in respect of matters of policy and efficiency, and not for legality of its action, which only the court can probe into, right? So these are actually why we need to have the judicial review mechanism as a judicial device to the parliamentary system, right? And in Malaysia, for example, we inherited judicial review policy from the common law, right? Which is, if it is under the common law, we have this particular theory of the doctrine of ultra vires, right? Which is the excess of the jurisdiction. So these are the common features of the judicial device mechanism in the administrative law. Next slide, please. Right. Apart from being a judicial device mechanism, right, we can see that the judicial review in Malaysia also act as a paternal supervisory role, especially under the criminal law, right, in which a paternal supervisory role upon the criminal courts in order to correct miscarriage of justice, which arise from four major categories. For example, if any subordinate courts had made any decision which is erred in law due to the misconception of law, for example, or maybe in terms of the decision actually occurred due to the irregularity of procedure, or maybe neglect of a proper precaution, or apparent harshness of treatment. So under the criminal law, for example, or under the criminal justice, if these four categories of situation occur, which has resulted to some injury to the due maintenance of law and order, and it created or resulted undeserved hardship to individual, therefore, the judicial review will be the main device or tool as a paternal supervisory role by the higher court, yeah, to correct, some sort like to correct the miscarriage of justice, right? Next slide, please. When we discuss about judicial review, sometimes the terms are interchangeable with the terms of an appeal. Therefore, there are striking similarity between the judicial review and appeal process under the whether it is under the criminal justice system or under the administrative litigation in court, right? So judicial review actually provides for judicial control, yeah, between an appeal in a broader scope, okay, and not review at all, right? So if let's say that in an appeal, the appellate court can re-examine both findings of facts and conclusions of law as to the legal consequences of these facts made by the inferior tribunal, it is actually different compared to a judicial review, because normally in an appeal, it is only by the application of the parties, especially from the aggrieved parties. But in judicial review, it is a court supervisory role within supervisory jurisdiction in nature and only available in exercising of the court's inherent power, which means for the judicial review in Malaysia, it can be either from the application by the parties, or the court may exercise its own motion, okay? Meaning that without any application of the parties, the court may exercise its own motion under the law, and they may call up any record from the subordinate court, right, as to see and as to look into, right, whether the decision or whether any order or ruling by the subordinate court, okay, are in compliance with the law, right? So these are the striking similarities between the judicial review as well as the appeal. Next slide, please. Well, what is the purpose of the judicial review policy in Malaysia, right? There are four main purposes. The first would be the protection of the individual against illegal acts of the administration, as for the example of wrongful dismissal. For example, a government officer, okay, being charged by any department for any wrongful or for any alleged maybe corrupt practices, for example, or any misbehavior, for example, but the procedures involved or the procedures taken by that body or any administrative government body are not according to the rules. Therefore, that particular officer has been wrongfully dismissed. And as to protect the individual right against any illegal act by the administration, judicial review will be the main device for that aggrieved parties as to check and balance. Secondly, providing remedies for wrong done to that particular person. Thirdly, judicial review is actually to ensure that administrative bodies act lawfully, and to ensure that if, let's say, that the administrative body acted unlawfully, it will be upon the judiciary as the third independent body, right, to look into the matter. And fourthly, to ensure the administrative bodies perform their official duties. This is under the context of the administrative law when it comes to judicial review policy. Next slide, please. However, there are salient issues when it comes to judicial review policy in Malaysia. For example, the issues of the right to be heard, right? Whether the administrative action, for example, for wrongful termination or dismissal of employment, have taken any step, right, to call upon that individual, right, to defend himself. Secondly, right to be legally represented, because normally, for example, even in the issues of any tribunal, whether the issues would be whether that particular person has been given a right to be legally represented, especially in the event that that person, whether he understand or not towards the procedures that has been taken by that particular institution, right? Right to be legally represented may be by the advocate and solicitor of his choice. Thirdly, the appropriate communication or notice. Normally, when the administrative body would like to take any action, the important part, whether the notice has been given for any legal action, for example, whether it is comply with any rules and procedures, right? Under any law. Okay. Number 4, the salient issues is actually pertaining to other relief, remedies, or specific relief. For example, in civil remedies, right? Whether an order of certiorari, mandamus, injunction, declaration, and so on. And fifthly, I believe this is also very important, whether that particular person, when he seek for any judicial review, okay, whether he or she has any locus standi, which is the legitimate grievance or adversely affected, right, upon his right, whether he has any locus to bring any issues or for the court to decide, yeah, under the pretext of judicial review. Okay, next slide, please. Hence, we can see that the judicial review aim, okay, has 2 major aims. For example, number 1, judicial review in Malaysia is there as to safeguard the rule of law. Okay, in Malaysia, the power has been given to the High Court, which has a duty to ensure that the subordinate court are operating within the provision of the CPC, which is the Criminal Procedure Code. Okay, this is actually in the context of administration of criminal justice, right? And the law is properly administered in these courts, right? Therefore, such revisionary powers may be exercised over under these 3 elements. First, the court, which is the High Court, will have the judicial review powers to exercise upon any procedural ruling. Okay. Number 2, over the interlocutory orders, or number 3, under the final orders that has been issued or declared by that particular court, right? Especially by the subordinate court, yeah? Especially when such ruling or order falls short of the provision of the law. Okay, then such particular order need to be corrected, and therefore it is the responsibility of the High Court to make such judicial review as to look into whether that particular order, sentencing, for example, are excessively or manifestly excessive, okay, towards that particular person or accused person in the criminal law context. Okay, so whether it is in compliance with the criminal law, we have a few criminal law in Malaysia, for example, our penal code, right? Our anti-corruption law, for example, whether it is in compliance. And number 3, whether it is in compliance with the judicial precedents, okay, under the pretext of ratio decidendi, for example, which the court, the lower court, need to follow any decision that has been made by the higher court, and whether this principle of law has been complied with by the subordinate court. Okay. Next slide, please. Right, we can see in Malaysia, in terms of judicial review policy, it has been codified under Section 31 of the Court of Judicature Act, and as well as under Section 323 up until Section 327 of the Criminal Procedure Code, right? Therefore, we can see, I have these 3 cases in which mention that the High Court may invoke the power of judicial review even from an informal sources or report. For example, in cases PP versus Marwan, there was this newspaper report pertaining to a case that was decided irregularly, okay, irregularly, right? From the newspaper report itself, without any application from the parties, it gives the High Court the powers to conduct a judicial review on the matter. Case number 2 is case P. Bumpo, which is a complaint by members of the public pertaining to an abuse of process in a particular court. These complaints also draw attention, okay, has drawn the attention of the court, right, to invoke the power of judicial review. And same with the case of Mohari Muhammad Jani, in which there are many ways. The court say that in this case, there are many ways in which the attention of the High Court judge in Malaysia may be drawn, okay, upon, right? Whether from the newspaper, letters of complaint, or requests made to the judges, etc., as to invoke the powers of judicial review to the High Court to review into the matter. So it is not just the application by the parties, okay? It is actually by the motion of the court on its own, and it can be drawn upon from any public information, okay, that exists, yeah. And it also take into the consideration the online sources, for example, okay, as a possibility for the court to invoke its powers. Next slide, please. Secondly, when it comes to the judicial review policy, it is also a tool as to prevent injustice and abuse of court process. Okay, we have in Malaysia under rules of federal court, the highest court in Malaysia, which is Rule 137, in which give power to the federal court as the highest court of the land in Malaysia to review its own decision, okay, to review its own decision as to prevent injustice, or abuse of the process of the court. We have a few cases, for example, in the cases of Chu Tak Fai, in the cases of Datuk Sri Anwar Ibrahim, and also Rovin Jyoti Kodeswaran, in which the court actually mentions that although the federal court have this additional power to review or to revise its own decision, the court say that such power ought to be used sparingly and in a very rare and exceptional cases. And I'm not sure whether you guys know or not, in Malaysia, we have currently the case of our former Prime Minister, Datuk Seri Muhammad Najib Tun Abdul Razak, in which it is originated from the High Court. He was charged for abuse of power. The High Court, after that, he appealed to the Court of Appeal, and he appealed to the Federal Court. And now, from the decision of the Federal Court, in which the court actually refused his appeal, now he applied to the same Federal Court. Okay, he applied to the same Federal Court as a final resort under Rule 137 in order for that Federal Court to review its previous decision, meaning that its own decision, right? So we are waiting for the outcome for this particular case, which is quite interesting. Therefore, under Rule 137, the Federal Court in Malaysia also may call upon any cases decided by the subordinate court. And it is not confined to cases before the Federal Court alone, but also any subordinate court, and such power may be invoked in order to prevent injustice. Okay. Next slide, please. Right. I think I would like to highlight 3 cases. Among all cases, I believe that these 3 cases is quite interesting, right? In which it is to show that the judicial review principle or policy in Malaysia actually are looking into a diverse, it covers a diverse aspect. For example, in the case of Indira Gandhi versus Director of Islamic Religious Department of Perak, you know, in Malaysia we have both civil law as well as the Sharia law. Under our federal constitution, Islam is actually our official religion of the Federation. However, there are always a battle of jurisdiction between Sharia and civil court, especially in terms of the conversion of religion, right? So in this particular case, Indira Gandhi applied for a judicial review against the decision of the Director of Islamic Religious Department of Perak, that in which this department has accepted the decision, the application by her spouse to convert their children, okay, to Islam, right? So in terms of this particular matter, the applicant actually, a Hindu mother of 3 children, turned to the court, right, when her husband left after an argument and forcibly taking their youngest child, a 11-month-old daughter, with him. And she had learned that he had converted to Islam and then converted all of their 3 children, okay, without her knowledge. So the issues here is whether the act of the Islamic Religious Department in accepting, right, the application of that particular conversion to Islam, okay, whether it is a lawful action. And the court mentioned that the federal court has interpreted our federal constitution and mentioned that the religion of a person under the age of 18 years old shall be decided by his parent or guardian, right, as requiring the consent of both parents. Okay, so in this particular situation, the court mentioned that whatever it is, there will be no unilateral decision in terms of the conversion of religion for their children. It must be both decision by the parents, right? Secondly, I would like to highlight the case study of Department of Environmental Department versus Kajeng Tubek. This is pertaining to the construction of the dam, the hydroelectric dam in Sarawak, right? So it involved major issues, okay, in which the applicant was the respondent complained about that particular situation, okay? So the court say that in terms of local standard, you must show to the court that you have the standing, right? The legal standing, okay? Because you cannot represent everybody and everyone in this world. And thirdly, to Dr. Mahathir Mohamad, our former Prime Minister versus Tan Sri Muhammad Siddiq Hassan, the applicant here challenged the appointment of the chairman member of the Royal Commission of Inquiry, okay? Royal Commission of Inquiry has been set up by our king to investigate into the matter. And he actually go to the court, okay, apply the judicial review to challenge that appointment. And the court has refused his application, and the court say that, well, it is justified under the law and there is nothing wrong, okay, pertaining to that particular appointment, okay. So actually, next slide. I believe that this is the last slide. I hope that my presentation is quite clear to you all, and I'm looking forward for the Q&A, and thank you very much.
All right, thank you, Dr. Ismail, for the presentation. Now, audiences, please give applause to Dr. Ismail. Yeah? All right, so it's our time to move to the question and answer sessions. As Dr. Ismail also understand Indonesian language, then silahkan audiences bisa bertanya dalam bahasa Indonesia ataupun bahasa Inggris secara langsung. Okay, I will first invite 3 questions from the audiences, can be also from the lecturer of Faculty of Law, UMP, also from guests. We are open to receive 3 questions from you. If you want to ask question, please raise your hand and then we'll give you the microphone. The material presented by Dr. Ismail already uploaded in the WhatsApp group of your faculty. So if you want to know, if you want to read again the material which is just presented, then you can read it later. Yeah. Okay. Who wants to ask a question? All right, Dr. Ismail, we already have one questioner from the student of Faculty of Law, UMP.
Okay.
Cek. Assalamualaikum warahmatullahi wabarakatuh. Good morning, Mr. Nur Fajri. I'm Nurul. Thank you for the opportunity for asking question. I'm from fourth semester. My question is, what rules can the touching in Malaysia application be applied when in Indonesia act against the Constitution, Mahkamah Konstitusi, and rules under the law against the law in Mahkamah Agung? Thank you.
Sorry, can you repeat your question? What law or what rules applicable is it?
What rules can the touching in Malaysia application be applied when in Indonesia act against the Constitution in Mahkamah Konstitusi and rules under the law against the law in Mahkamah Agung? Thank you.
All right, thank you very much. Nurul, is it? Okay, thank you. Well, in Malaysia, the highest court of the land is the federal court. Okay, you guys can hear me, is it? Boleh dengar ke? Okay, right. The highest court of the land in Malaysia is the federal court ataupun Mahkamah Persekutuan, right? The federal court in Malaysia has been given the power even to interpret the constitution of Malaysia. One of the jurisdiction of the federal court in Malaysia also involve the jurisdiction to interpret the law as to see whether there is any inconsistency between the federal constitution as the highest law in Malaysia and the subordinate or any other written law in Malaysia. Okay, so the rule applicable is actually we have a Court of Judicature Act, okay, as a substantive law in Malaysia that empowers or gives jurisdiction to the higher court. Okay, in Malaysia we have two tier of court. The first tier is the higher court. The second tier is the subordinate court. Okay, we have three courts under our subordinate court, which is the magistrate court, the session court. Sorry, we have two courts, right? Magistrate and session court as the first court of instance, and we have three higher courts, which is the High Court, Court of Appeal, and the highest court of the land is the federal court. We do not have any dedicated constitutional court. Like in Indonesia, I believe they have a dedicated or a special court, which is the constitutional court. In Malaysia, we have only the federal court under our constitution. And our federal court, as I mentioned to you, empowers that particular court to interpret the federal constitution. So this is very, very important as the court being empowered to review, even to the extent to review whether any act of the government is consistent or inconsistent with the law, which is inclusive of the federal constitution. And we have quite a number of cases of that. For example, in terms of whether the act of federal government, for example, okay, in giving allocation of money to the state government, okay, whether it is according to the distribution as stated in our federal constitution. So there are cases on that. So in terms of that particular situation, the federal court will have such powers. Is it okay, Nurul? Am I answering your question?
All right, thank you, Dr. Ismail. That really answers Nurul's question. Okay, so yeah, we invite the second questioner from another students. Okay, can someone give the microphone?
Ya, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
My name is Priyo Budi Tri Utomo, doctor. I'm from semester 6, and I wanna asking, do you think judicial review is going to harm a constitution that has already created an authorized agency?
Okay. Thank you, Budi.
Thank you, sir.
Okay. Whether judicial review will harm the constitution. Okay. The basic principle of the judicial review is actually to give the power to the court, which is the independent third party. When I mentioned that as independent body, as an independent third party, meaning that the parties, meaning that the aggrieved parties will go to the court in order for the court to decide. For example, in Malaysia, if after the general election, if one parties or one candidate won that particular general election, okay, then there will be an avenue for the aggrieved party to go to the court, yeah, to question the validity of that winning parties, or whether our election officer has done their role, for example, right? So judicial review is the mechanism, one and only mechanism, if let's say that they don't know where to go. For example, if they feel that they've been aggrieved by the action of the government that has been taken under the pretext of federal constitution, okay, now where they should go, okay, for example, under the wrongful termination, okay, of employment, for example, or any act by the government. If they lodge the complaint to the government officer, for example, or any other agency, there will be a conflict of interest. Same goes as if they are going to lodge the report to the police for any infringement of their rights, right? Because it is the police, for example, are still the government agency or government arms of the government agency. So let's take, for example, the right to life under the constitution, okay? And there is any death in the custody, for example. First and foremost, where are the family members will go to lodge their complaint if they feel they are dissatisfied with the action of the police officer, or if, let's say, that they feel that their family members had died suspiciously. If they lodge the report to the police, for example, it may actually involve any conflict of interest. Yes, the police will conduct a proper investigation, but at the same time, for example, they will go to the court, to the magistrate or to the court to look into the matter. For example, right to life again, when the parties actually dissatisfied with the post-mortem conducted by the doctors, right? Where they should go to lodge their complaint. If they lodge their complaint to the doctor, for example, of course, they are not going to entertain the complaint. If let's say that they go to the police officer, of course, the police officer will conduct the investigation. But the effective mechanism is actually they are going to the court, okay, for judicial review to look into the matter, whether the refusal of the doctor to perform the post-mortem is justified. So, under the pretext of the rights of the citizen under the federal constitution, it is very important that the court, as the independent body, to be given. That's why inherent jurisdiction means that the powers of the court, which is not contained specifically under the law, but it is some sort like the powers of the court to review any action, okay, as the third independent body and considered to be the trusted institution, okay, to make decision on the matter. So that's why we need to balance the interests between the administrative body or the government, for example, under the federal constitution, because the constitution itself provides for three independent bodies, which is the government, the legislative, and the court. And the court, as the independent body, will have the jurisdiction to interpret the law whether it has been complied with or not. Okay, so I hope Encik Budi, saya menjawab soalan Encik Budi tadi. I hope that I answered your question. Thank you.
All right, thank you, Dr. Ismail, for answering Budi's question. So I think we still have time for the third questioner. All right, so please give the microphone to that lady. Boleh.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Perkenalkan, nama saya Yusmida Sari dari mahasiswa semester 6. Izin bertanya kepada Dr. Nur Fadjil Ismail. Pakai bahasa Indonesia?
Boleh. Pelan-pelan tapi ya.
Boleh.
Izin bertanya kepada Dr. Nur Fadjil Ismail. Badan apa saja yang mengurus judicial review di Malaysia dan seberapa luas kewenangannya? Apakah masyarakat hanya peduli terhadap judicial review atau tidak? Atau memiliki wewenang untuk menyelesaikan aplikasi lain? Gitu.
Tiga pertanyaan ya. Jadi satu. Oke, could you please repeat?
Please repeat.
Satu.
Oh, satu-satu.
Ya.
Yang pertama, badan apa saja yang mengurus judicial review yang ada di Malaysia dan seberapa luas kewenangannya? Terus yang kedua, apakah masyarakat hanya peduli terhadap judicial review atau tidak? Yang ketiga, memiliki wewenang untuk menyelesaikan aplikasi lain. Bagaimana, Dokter?
Oke. Boleh interpret tak soalan nombor 3 itu?
Yang
Encik Nawat.
Nomor 3.
Yang nomor 3 sambungan dari pertanyaan yang nomor 2, apakah masyarakat hanya peduli terhadap judicial review atau tidak, ataukah memiliki wewenang untuk menyelesaikan aplikasi lain, gitu?
Oke, alright, baik, paham.
Terima kasih.
Terima kasih. Sunda Sari ya, terima kasih. Okay, I think in judicial review, nama dia pun adalah judicial review. So it is the power given to the court actually. And to answer your question, whether the rate of success ataupun apabila dibawa kes tersebut jadi seberapa luas. In Malaysia, when it comes to the judicial review policy of the court, okay, the court actually has the wide power, satu kuasa yang luas dalam membuat keputusan terhadap permohonan oleh pihak-pihak. Okay, but the rule adalah, okay, there are the rule towards that, meaning that the court should take extra step. Okay, meaning that the exercise of that power should be sparingly, maknanya dalam keadaan-keadaan tertentu sahaja, barulah kuasa tersebut boleh digunakan oleh mahkamah ya, untuk semakan kehakiman ya. We call it semakan kehakiman in Malaysia. Okay, so meaning that it should not be applied or invoked on a regular basis. Maknanya bukanlah maksudnya saya katakan tadi, kalau berdasarkan kepada the court may invoke even from the newspaper report, okay, or the court may invoke even from the letter of complaint, meaning that without without application by the parties, also the court can invoke the power. Okay, but it does not mean that all newspaper news, okay, or clipping, for example, and not all like posting in social media can invoke that particular law or jurisdiction of the court. Only in the exceptional situation. As I mentioned to you, if you remember just now, there are 3 cases, okay, letter of complaint and also the news clipping, okay, they are actually pertaining to a report by that media against the court, okay, meaning that, oh, the court has decided wrongly, for example. Only then, okay, the court will invoke the judicial review to look into the matter, okay, to see whether that particular case has been decided accordingly, okay, or for instance, if let's say the application by the parties are due to the fact that they have been infringed the right and the livelihood of them to own a property or to own the land. Okay, in Malaysia, if let's say that you are the owner of the land, your right may be deprived by the mandatory land acquisition, but there must be a compensation to be given to you. If let's say that the government acquired the land, you feel aggrieved because there are no compensation being given, or if there are no money or the compensation are not enough, okay, then you can go to the court, okay, to review the decision of the government in taking your land, okay. So the rate of success depending on the matter itself. If you to ask me, if you go to the court, whether you are 100% guarantee of the success, it depends on your case. I mentioned to you just now that there are 1 case in Sarawak. In Kajing Tubek, the court say that you cannot represent everybody in that particular kampung if you feel that they are a development by the government to build any hydroelectric. You cannot represent everybody in that kampung to lodge a judicial review, okay, and to impose the court to fine or to sentence that government agency for a fine or of criminal sanction. So you are lack of local standard. So it is same here. For example, there are requirement. For example, you have to look into the matter. If you are filing or if you make any application, you must make sure that you have a merit toward the case. Okay, so that is something in which the first and the second question. For the second and the third question, whether there are any other bodies. Yes, there are any other body, for example, but they are dedicated depending on the cost of action. For example, you are buying a house. At the end of the day, you feel aggrieved by the act of the developer in the late of giving the house key, vacant possession. Okay, accordingly, you sign a contract. The house need to be ready by 24 months, but it took longer than 24 months. Okay, now you want to review the act of that particular developer. They are special body actually, not judicial body, but a body in which it will entertain your complaint as a home buyer. Same goes if you are the consumer, for example, you feel aggrieved by the act of the seller, okay, not producing any price tag or whatsoever. So in answering your second and the third question, yes, there are any other body that will receive your complaint, but that is not in a form of judicial review. Okay, that are just a complaint, that are just a body that has been established to accept your application to review the act of that particular person or institution within the power or jurisdiction of that body. For example, for homeowner tribunal, we have a tribunal for that, as I mentioned to you. It is only within the purview of that particular tribunal. Okay, they cannot review the law, they cannot review in terms of constitution, okay, as the right of the ownership, for example. Okay, so I believe that is the answer that you're looking for. Sundasari, is it okay? Boleh ke?
Yeah, that really answers her questions, Doctor. And it's really a comprehensive answer from you. And I think a lot of students here are really eager to ask more questions, Doctor. As this is a very interesting topic, they like to compare the situation in Indonesia and also in Malaysia. And if then we discuss this in the session, it will take more than 2 hours. So probably later, Faculty of Law will need to invite Dr. Ismail to be a guest lecturer or visiting professor here in Faculty of Law. Give applause to Dr. Ismail. Yeah, for your information, because UMP has an agreement with University Science Islam Malaysia, we have signed the MOU, so it's really possible, yeah, to invite Dr. Ismail to deliver a lecture in the academic calendar. So it's not only it's not only one meeting, but it can be 3 or 4 meetings, yeah, inviting Dr. Ismail to give lecture to our students. All right. So yeah, thank you very much, Dr. Ismail, for sharing with us. It really broadens our knowledge, yeah, and we really appreciate your coming to this international seminar, even though it's done virtually, but we find it really beneficial and really fruitful, Doctor. So due to the time limit, so once again, on behalf of UMP, we thank you very much for your participation in this international seminar as a speaker. Once again, give applause to Dr. Ismail for his coming virtually to this meeting. All right, thank you, ladies and gentlemen. So that's the end of the first session of speaker presentation. Then it's our time to move to the second speaker of this international seminar. He has been here since the morning. And yeah, before we start, once again, let me first invite Professor Smith to come to the stage. Everyone, please give applause to Professor Smith. All right, ladies and gentlemen, we'll have around 5 to 7 minutes break in case you want to go to restroom or you want to take a break for a moment, because Professor Smith's material will be really interesting and it really needs your attention. Yeah. So Prof. Smith and I allow you to take a break for 5 to 10 minutes. Yeah. Thank you. Why do we prepare this cable if you need it? Ada lubang ini. Apa konsepnya? trivial to you all, to us, yeah, so that we can gain something new from the perspective of judicial review in Germany. All right.
Very low. Okay. 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 Otherwise. Yeah, no problem.
All right, so before we start the presentations, then let me briefly introduce our second speaker, Professor Smith. Well, so Professor Thomas Smith is a DAAED lecturer at the Faculty of Law, Universitas Gajah Mada, Yogyakarta. He is also an adjunct professor at the University of Göttingen, Germany, and he has an extensive national and international academic teaching experience. Professor Smith got his doctoral degree in 1989 and obtained his professorship at the University of Göttingen in 2005. Meanwhile, his areas of expertise are European law, in particular EU internal market law, European Constitution, fundamental rights, foundation of European Union law, and the EU in the general theory of state. The second one, his expertise is on the constitutional law, in particular fundamental rights, constitutional review, constitutional problems of supranational integration, and the third one is administrative law, in particular rule of law, and then comparison of laws in the field of public law, and also he is expert on the legal terminology and multilingual communication in public law and European law. Professor Smith also has a number of main publications from 1989 to the present time, including the one as the editor and co-author of the book entitled Basic Vocabulary of European Union Law. Besides, Professor Smith also has the website in Indonesia, and you can access his website. As you can see in the screen, there are a lot of resources of law that you can browse and to enhance our knowledge in the legal perspective. All right, I think without further ado, Professor Smith will have 45 minutes for the presentation, and the time is yours, Professor.
Yes. Selamat siang. Thank you very much for the invitation. Nama saya Thomas Schmidt. Saya dosen tamu Jerman di Fakultas Hukum UGM. I'm sorry that I need to continue with English. My Bahasa Indonesia is not good enough for an academic presentation. Thank you very much for the very interesting invitation to this interesting international seminar. It's already the second time that I cooperate with UMP, but the first time that I really could come to Purwokerto due to the pandemic. And thank you to the organizers, thank you to the dean, to the rector for the very interesting invitation and for the warm welcome in Purwokerto. Ladies and gentlemen, I will talk about judicial review of administrative action, that means of the acting of public administration in Germany, which is just a model, just one good example. And I have seen, comparing my lecture to that of Dr. Ismail, which I found very, very interesting, that of course there are lots of differences between the Malaysian system and the German system, because we are not a common law system, we are continental legal system like Indonesia. However, when you go into the details, I don't have the time now here, but you go to the individual principles and details, lots of details he presented would be the same in Germany. But coming from a different perspective, we would go to the same details. That's quite interesting. Let me talk about some backgrounds of the German system. Well, first of all, there is a need for judicial control of public administration. We must ensure the rule of law. We must protect the citizens' rights. And we must prevent arbitrariness and corruption in public administration. This requires control of the executive by professionals with the authority of the third power. Non-judicial mechanisms are also helpful, but according to the West European experience, we can clearly say they are not enough. You need the power of a judge to control the executive. It's not enough to have intra-executive mechanisms, which we have to. There are some historical backgrounds. Germany had already a tradition of rule of law in the 18th century. The Indonesian term negara hukum does not really come from the Dutch term Rechtsstaat. In reality, it comes from the German term Rechtsstaat, which is, however, the same. It has the same historical background. It's originally a different concept of rule of law, but it has become the same in the second half of the last century. In Germany, independent administrative courts were already introduced in the 19th century. The same in France. So we have a long tradition on that. However, ladies and gentlemen, a resolute implementation of the rule of law and a really working protection of human rights only appeared in Germany under our present constitution, the basic law for the Federal Republic of Germany of 1949. So, despite having a long tradition in history, only after the Second World War, when Germany restarted after the horrors of the Nazi regime, did the system really work. So if there are problems in Indonesia that it does not work correctly yet, be aware that other countries also, they took a long time before the systems worked. Well, the rule of law is a constitutional principle in Germany, as in Indonesia under Article 1, Section 3 of the Constitution of 1945. And in Germany, it has been concretized in detail in the rich constitutional jurisprudence. Hundreds of constitutional court decisions explaining what rule of law really means. I sometimes give a guest lectures just on that. It would be a 90 minutes guest lecture. We also have a comprehensive and effective guarantee of fundamental rights. These are the human rights anchored in the Constitution. In Indonesia, they are called human rights. The rights anchored in the Constitution, ladies and gentlemen, and that applies to Indonesia too, they are directly binding law. They are not just some political slogans. They are binding the whole executive and every judge. In Germany, we even have a fundamental right which is called general freedom of action. That means the right to do or not to do everything you want. So if I kiss my wife on the street and the policeman comes and say, no, you don't do that, I can go file a complaint against that before the authorities or a legal action before the administrative court. Because I have the fundamental right, the human right under the Constitution to kiss my wife at the street. So it's a lot of, that has been important when the society modernized and the young generation showed different behavior than the old ones, that there were many aspects considered as protected by the human rights, which the older generation could not accept. This is an important background. Also, of course, we have the judicial independence, not only guaranteed, but also required. The Constitution demands the judges to be independent. The most important, however, is the fundamental right to have recourse to the courts against any violation of one's own right by public authority. That we have a constitutional right of effective legal protection by the court. And if it doesn't work, the citizen can file a constitutional complaint before the Federal Constitutional Court. However, there are also some social and cultural backgrounds. The Germans trust more in the courts than in non-judicial control. That's quite interesting. It's different in some other countries. There is a high degree of professionality, integrity, and independence of the judges. But there's also some not so sympathetic element in the German mentality, a high readiness of the citizens to bring legal disputes before the court. They like to fight before the court if they think they are right. Therefore, this all has pushed the judicial control system. Well, we have three kinds of administrative courts. We have a system of separate specialized courts in the field of administrative law in all instances. At the bottom, there are 51 administrative courts with chambers of 3 professional judges plus 2 honorary judges in oral hearings. So they are everywhere in every province. Then we have 15 higher administrative courts for each land. Just 2 landers, Berlin and Brandenburg, they share 1. And on top, we have a Supreme Federal Administrative Court. It is a Supreme Court of review on points of federal law, not of land law. And in some cases, it's even the court of first and last instance. This Federal Administrative Court has 55 judges. So you see, it's a huge judicial machine. It's not a little court, it's a big machine. Let me talk about important characteristics of administrative jurisdiction in Germany. First, we have the limitation of judicial review to the protection of subjective rights. That means protection of the personal rights of the citizen. The primary objective is the protection of the personal rights of the citizen, not of the objective legal order. That is different, for example, in France. Legal actions are, with very few exceptions, only admissible if the plaintiff claims a violation of his own rights. He must say, my rights have been violated by the bad authority, the bad executive. That means he needs to be directly, personally concerned. It's not enough that the neighbor is concerned, or his family, or his wife, or husband. It needs to be himself. The next element is we have a system of legal protection which is based on different forms of legal action. The requirements for the admissibility of a legal action and also of the well-foundedness of a legal action largely depend on the form of action. The students need to learn that. It's a lot of work for them, because the form of action depends on the kind of the court decision seeked. What does the plaintiff want? The annulment of an administrative decision, an injunction, an order to the authority, a declaratory judgment, or what? The most important forms of action protect the citizen against so-called administrative acts. You can also translate into English as administrative decision. This would be the term used in Southeast Asia usually. That means a regulating individual decision of the public authority. The term administrative act, which comes from acte administratif in French law, has been incorporated in inspiration by the French law at the end of the 19th century. Ladies and gentlemen, that was interesting. At that time, France was the biggest enemy of Germany. But anyway, the German scholars were strongly inspired by the simply much better French administrative law and copied and pasted a couple of important concepts from France into the German law, which are still decisive. Lots of our administrative law in Germany focuses on the Act Administrativ, the Verwaltungsakt, the administrative act or the administrative decision. The students need to learn hundreds of hours just on that. Third, we have a complicated but very effective system of interim protection. The idea is that you need protection already during the proceedings. Otherwise, it will not work correctly. So, if the court decision comes late, there is a problem with the cable, I think. Maybe need to check again. No. Maybe it's with this connection, yeah. Sorry. It should come back.
Still searching the circuit. Okay.
Okay. Now it comes back. Sorry, that was yeah, that's helpful. So, the citizen needs already to be protected during the court proceedings, which can take long times. In Germany, easily 1 or 2 years. And at the higher administrative court, up to 5 years. Finally, the German system builds on the professionality, integrity, and also the independence of the judges. Ladies and gentlemen, this is a social prerequisite of the system as we have that in West Europe. The judges are highly qualified, they are well-paid legal professionals who cannot be bribed. We have practically no corruption in the judiciary. And they are committed to their mission to enforce the law effectively against the executive. So, one thing you need to understand if you want to study the West European systems is that the courts are not shy to kick down the president or the government. They give orders and the government must follow. And it can be a 30-year-old judge who gives orders to the government. And that's we call separation of powers, the Montesquieu model. But they are also not afraid of the government. They are not afraid of the parliament. They are not afraid of influential politicians, and the judges are also not afraid of political, social, or religious pressure groups. Some case like that with the former governor of Jakarta, that could not happen. If 700,000 haters are demonstrating on the street, the judge will still say, so what? I decide on my case according to the law and not to that what the people on the street want. This independence is a prerequisite if you build your system of control of the public administration on the judiciary. The judges can be young in Germany. This prevents gerontocracy, the dictatorship of the old. And it also prevents entanglement with the elites, because the young judges are often a little bit more rebellious. Socially, it's interesting that the young administrative judges are particularly intellectually independent, more than the judges in criminal law or in private law in Germany. It's a tradition. They often, the lower courts, do not even follow the jurisprudence of the High Court. And they criticize the High Court and say what they have done is wrong. And if a couple of lower administrative courts criticize the jurisprudence of the High Court or of the Federal Court, that has an impact in the long term. And it always causes a very intensive scholarly debate. We have a general recourse to the administrative courts in all public law disputes, which are not of constitutional character. and which are not allocated by special statutory law to other courts. This causes some problems sometimes, because we need to define the dispute. Is it a public law dispute or is it a private law dispute? The private law dispute goes before the ordinary court. The public law dispute before the administrative court. The delimitation can be quite difficult sometimes. Let me briefly talk about the forms of legal action before the administrative court. So if you were German students, you would need to learn that for 50, 60, 70 hours. You would just study that. The first legal action is that of action for annulment of an administrative act or administrative decision. This is the most common one. Usually, under the law, it's only admissible after an administrative review of the attacked administrative act, the attacked decision of the public authority, in preliminary objection proceedings. So before going to the courts, the citizen must file an objection before the administrative authority itself, so that the authority has the possibility to review its decision. And if this authority does not want to do it, goes to the next higher authority, which will decide on the objection. And only if the objection is rejected, then the citizen can file a legal action before the court. So we want the public administration to have the chance to correct its wrongful decision itself and to learn from that. This has been a very good experience with this. The second action is for the issue of an administrative act, also under the same conditions as the action for annulment. That means the citizen seeks an administrative decision which he has asked for, but which he did not get. That can be, for example, a license, a permit, an approval of the administration which he needs under the law, but the administration does not want to grant it. Now we come to the question in discretionary cases, where the administration has a discretion. If the case is not yet mature, if not everything is clear yet, the court will not oblige the administrative authority to issue this administrative decision, for example, to give the license, but it will hand down the obligation to decide on the matter, but taking the legal view of the court into consideration. In practice, this plays an important role because maybe the refusal of the license to the citizen was not legal for the reasons the administration mentioned, but maybe it was not clear if the refusal could not be based on other reasons. So then the authority needs to decide again, but is bound to follow the legal considerations of the court. You see a quite complicated system of interaction in the German system of separation of powers. The action for performance is for another administrative action than issuing an administrative act. For example, the citizen wants to have some information. To give information to the citizen is not a decision, so therefore it's not considered an administrative act or administrative decision in the German law. The action for prohibitory injunction would be to stop the authorities to do something which is not giving an administrative act. For example, the citizen, a company, wants the court to prohibit the public administration to give information on his company to a competitor. He might have applied for a license, needed to send some documents or materials, and the public authority gives this information to a competitor who wants to know, oh, how can I produce this product? I can learn from that. This would be an example. The declaratory action is about the existence or non-existence of a legal relationship, or it can be about the nullity of a seriously and evidently unlawful administrative act. If the decision of the public authority is not only illegal, but seriously and evidently illegal, if it's very clear, under certain restrictive conditions in the law, this administrative decision will be void from the beginning. That means that means that the citizen does not even need to follow, but the citizen may want to have legal security about that. A very important legal action is the action for establishment of the unlawfulness of a settled administrative act. The plaintiff seeks a declaratory judgment of the court that an administrative act, an administrative decision, which has already been executed or followed, was unlawful. It cannot be annulled anymore, but it can be declared a posteriori unlawful. This is only admissible if the citizen has a justified special interest in this declaratory judgment. For example, if the citizen wants to prevent similar measures in the future. A good example would be the prohibition of a demonstration by the police, just maybe 5 minutes before the demonstration was supposed to start. That cannot be annulled anymore because the demonstration will not take part at that day. So that administrative decision is gone. But the citizen may play, for example, the students in Jogja, they may play a similar demonstration for the next weekend, and they don't want that to happen again. This would be a classical case for this kind of legal action. Also, to restore the plaintiff's good reputation, or to prepare a lawsuit for state liability. Maybe the organizers of the demonstration had already rented a car, rented the music, rented an assembly hall for closing of the demonstration, all that, and they need to pay for that. They have a big damage, and the police prohibited their demonstration illegally. They need that declaratory judgment of the administrative court to ask for compensation and money. Practically, this plays an important role. The last one, ladies and gentlemen, it's also interesting. That is an application for judicial review of legal provisions, sub-legislative legal provisions like bylaws or regulations, ordinances at the local level or at the land level. At the federal level, they cannot do this, would be exclusive right of the Constitutional Court. Such application to review, for example, executive regulation of the land government is admissible within 1 year after publication. And this application cannot even only be filed by the concerned citizen, but even by a concerned authority. An administrative authority which would need to apply or enforce this government regulation, they can also file an application before the administrative court. Can you please review? We think that this government regulation is illegal. This instrument, ladies and gentlemen, has been very important in the legal protection against the COVID-19 restrictions in Germany. You may have read that in Europe, COVID-19 was more serious than in Indonesia, and the restrictions were far more serious. Curfews, contact prohibitions, you were not allowed to have visitors in your house anymore, closure of restaurants, bars, cafes for several months, and so on. These COVID-19 restrictions were usually imposed by executive regulations of the land governments on the basis of a federal statutory law. So the citizen could apply for judicial review of these ordinances, the regulations of the government which imposed the COVID-19 restrictions. This was very important. There have been, all in all, there have been more than 750 court decisions just on COVID problems in Germany. Let me talk briefly about interim protection. What is special in Germany is that an action for annulment, but also already the objection before the administrative authority, has an automatic suspensive effect. What does it mean, automatic suspensive effect under the law? The contested administrative act does not produce legal effects until the court has decided. It cannot be enforced against the citizen, and the citizen does not need to follow. For example, you get the administrative order to tear down your house, which you have built illegally, maybe on the fields where it was not allowed. You file the legal action until the court has decided you can still live in your house. You do not need to follow. This is important to prevent fait accompli. That's a French term. That means accomplished facts where the authority makes an illegal decision, executes it, and then the citizen can go to the court, but the court cannot protect him anymore effectively because, for example, the house has already been destroyed. In practice, it plays a very important role in Germany. It protects the citizen very effectively against arbitrariness of the public administration, but it can also delay the law enforcement against the bad citizen considerably. You see, the guy who has built a house illegally, he can still live in that house, maybe for 2-3 years. If he takes first an objection before the administrative authority, then a legal action before the administrative court, and then a remedy against that decision before the higher administrative court, it may happen that he can stay in his illegally built house up to 5 years. That is a problem. Or, what if the administrative decision granted him a right? For example, he was allowed to build the house, but the neighbor does not want him to build the house in his neighborhood. Then he may need to wait several years before he can finally make use of his license. For that reason, this system has been cut down a little bit recently to protect also the citizen, but also the administration against abuse of this legal remedy by the citizen. In practice, this is very important. Many decisions are already taken in interim decisions of the court. The court can be asked to decide to maintain or to stop the automatic suspensive effect. And these interim decisions of the court are in practice often more important than the final decision on the merits. We have also interim orders of the courts in other cases, for example, against the COVID-19 restrictions. We have that too. That played a very important role. The regulations of the land government, which imposed the most serious restrictions on the citizens after the Second World War, they often were only in force for 2 or 3 weeks, 4 weeks, and then they needed to be replaced by a new one. So the court could not take a year to decide on these government regulations. It would need to take an interim decision, and that would provide the effective protection of the citizen. You see, this is a big problem, but what all West European countries have. The interim protection protects the citizens against fait accompli, but on the other hand, he can abuse it. So you need to find a balance. Well, let me talk very briefly on the scope of judicial review. What do we review? The first is only legality, not expedience of administrative action. That is a problem when I teach that in Indonesia, because they often have problems to understand. Expediency, that means usefulness, appropriateness, practicability, morality. The morality of a decision cannot be questioned by a court, because the court is only allowed to questions on reasons of the law and not on morality. The same for religious considerations, practical considerations. Decision of the public authority can be stupid, it can be unpractical, it can be unfair, but it can still be legal. In this case, the judge is not allowed to interview. We have separation of powers. The role of the judge is limited to control the compliance with the law. You may understand that to distinguish what is an aspect of legality, what is an aspect of expedience, of usefulness, political correctness, morality, and so on, that distinction can be really difficult. Lots of doctoral thesis just about this topic. Well, second, by the way, we would not have a review of good governance. That may be interesting, because in Germany, also in France, unlike in the Netherlands, we consider good governance not a legal concept, but a political concept. Why? Because most of the principles of good governance, as they are known in Indonesian law, cannot be applied objectively and precisely by the court. But the court is only allowed to decide on the law. The judge must not come up with political reasoning or practical reasoning. So, some good governance elements, like rule of law, of course, they are legal principles. Some good government principles, however, are more political principles. That means they are only binding, legally binding in Germany, if they have been enshrined and concretized in a specific law. That is the difference, for example, to the Dutch system. Well, next, I would just like to introduce, we have a very elaborate system of elements of legality. But I cannot talk about that now here in detail, because this would be another lecture of at least 45 minutes. What I would like to say, it's a comprehensive, rational, and logical structured system. A system like that has only been developed after the Second World War. In German administrative law, unlike in France or in particular in common law, we do not have a numerous clauses of grounds of review. Everything is a ground of review. Every missing element of legality turns the acting of the public administration illegal and can lead to the annulment of the administrative decision, the administrative act. So it's a more comprehensive system. In reality, in the French administrative law, it's very comprehensive too. It's the same. In British law, in common law system, very often the grounds of review are quite restricted. It's only a limited number of grounds of review, like my colleague has presented. We all know them in Germany too, but in the German law, every element of legality must be met by any acting of the public administration. You may understand that the lawyers like that. You know what that means in practice? You need more lawyers. You need more administrative judges, and you need more lawyers in the public administration. A lot of lawyers who make sure that the public administration meets really every legal requirement of the law. We divide two aspects: legality of form, that's external formal aspects, and legality in substance. The most important is that all administrative action must comply with all higher law. This includes international treaties, not only the statutory law, and this includes human rights, and this includes also the Constitution. So, the public administration is directly bound to the constitutional rights of the citizen, which are anchored in the Constitution. So, this is not a problem of a specialized human rights court. Every court in the country, in particular every administrative court, has the mission to enforce the human rights under the Constitution, but also those under the International Human Rights Treaty, effectively against the executive. And, ladies and gentlemen, against any executive. Doesn't matter if this is the local policeman in the street or if this is the Prime Minister. That is an important aspect. Well, ladies and gentlemen, I come now to my last point. We have a restricted review of discretionary decisions. This is also a big topic in Indonesian administrative law, as far as I know. We have that. What is the limit of the discretionary power of the public administration? In Germany, we have a sophisticated doctrine of the incorrect exercise of discretionary power. And if there is any Ermessensfehler, any case of incorrect exercise of discretionary power, then the court can intervene. But the court is not allowed to replace the discretionary decision, the political decision of the executive by its own one. What is interesting is that these doctrines are different in Germany and in other countries. In France, they have another one. In Britain, they have another one. This is often a topic on international conferences on administrative law, how to deal with the problem of discretionary power. Okay, ladies and gentlemen, that would be my presentation. Thank you very much for your attention. I'm sorry for the technical problems here, but that can happen with the cable. So, and I'm waiting for your questions. Thank you.
All right, thank you. Let's give applause to Prof. Smith for the presentation. All right, so it's time for us to invite 3 questions from the audiences, because I believe that it's really interesting legal system there in Germany, that we can say that it's more complicated than the Indonesian one. Yeah, Professor. So, yeah, once again, we invite the students who wants to ask a question dealing with Professor Smith's presentation. Okay, maybe from Mbak Nurul, you can raise another question.
Okay, hello, Professor. Guten Morgen. I'm Nurul from 4th semester. My question is, I only read a few studies about it, but some journals wrote that Germany adopts judicial review as their preventive step if there is a legal vacuum. If you watch the YouTube channel of the Indonesian Constitutional Court, there will be a trial every day, most of which are judicial reviews. What made German can apply this in German, and can Indonesia also adopt it? Thank you.
All right, thank you. You may answer directly.
Yeah, I'm not sure. Thank you very much for your interesting question. I'm not sure if I have understood everything correctly, but the main approach, and it's the most strongest in West Europe, in Germany, is that the protection of the citizen is done by the courts. So judicial review before the administrative courts, but also in other cases before the ordinary courts, is the most important mechanism to protect the citizen. And it continues before the Federal Constitutional Court. In Germany, every citizen can file the legal remedy of an individual constitutional complaint. That means he can go to the Federal Constitutional Court or even to the Land Constitutional Court, there too, and complain, my fundamental rights, my human rights under the Constitution have been violated. That can be a violation by the law, that can be a violation by public administration, but it can also be a violation by a court. So, and the citizens do this. That means behind all the system of non-judicial mechanisms plus judicial mechanisms, there is always the big threat: the citizen may go to the Federal Constitutional Court and ask it for intervention. The Constitutional Court cannot intervene on the questions of the statutory law, but it intervenes on the questions of respect of fundamental rights. So, if an administrative decision has violated the fundamental rights, for example, the rights of the students to demonstrate on the street, under the right to assembly under the Constitution, this is a question what the Constitutional Court can answer. The fact that we have 5,000 to 6,000 individual constitutional complaints every year, this underlines the importance of this legal remedy. Moreover, the courts must grant effective legal protection. That is a human right under the German Constitution, a fundamental right. If the courts have not protected the citizen effectively, in, for example, misunderstanding this human right of legal protection, that can also be a violation of constitutional rights, which can be judged by the Federal Constitutional Court. And this, ladies and gentlemen, is a big shame. It's a big, big shame. If the Federal Constitutional Court states that the Supreme Court, for example, the German Federal Court or the Federal Administrative Court, has violated the human rights of the citizen, that is a loss of faith. So already that threat of that mechanism helps a lot to invite the courts to take their mission of legal protection effectively. Does this answer your question?
Yeah. Okay, thank you, Professor.
Okay, thank you, Prof. Smith, for the comprehensive answer. And I saw another questioner over there who wants to ask. Okay, the one from the back. You can come a little bit forward. Someone please give the microphone to him.
Good afternoon, sir. My name is Sudiko. I have any question about a system building on the professional integrity and independence of the judge. The question number one is, according to the professor, justice system in Indonesia compared with Germany can be good or not, and then what we can learn from the Germany legal system. Then in Indonesia, the judges can spread about the influential political, not spread by political interest. How about in Germany? Something political interest, and then sorry, sir, I'm.
That's fine.
Yeah.
The win is that. Okay, thank you.
Yes, thank you very much. That is an important question. Ladies and gentlemen, first of all, we must know that this is a different cultural background. So, Indonesia is in the East Asian cultural tradition when handling the law. Germany is in the West European tradition. In East Europe, it's already a little bit different, even within the European Union. Moreover, Germany has been one of the worst guys in the Second World War. It has committed the worst crimes. And after the Second World War, it was controlled by the Allied forces. And the new German system, they wanted to show, now we are the good guys again. So they established judicial independence, and the courts took that seriously. Not only the administrative courts, also the constitutional courts. We now know, there are reports that at the beginning of the Federal Republic of Germany, the federal government wanted to dissolve, to destroy again the constitutional court because it was so independent. But they could not do, because the Allied, the French, the British, the Dutch, the Americans, all were watching them. So, how are you organizing your country now? And then they could not do, and the Constitutional Court was really independent. And this inspired other courts also to become really independent. And then it developed a certain feeling in the German population that this is the right way, because the population supported that, in particular the independent position of the Constitutional Court, which must not be the body of the government. It must be the guardian of the Constitution against the government too, and even against the parliament. So that is an historical background, which of course is missing in Southeast Asia. So you need to understand that. Moreover, the position of a judge is highly renowned. So you have a very good reputation. A judge in Germany, like in Britain or in France, is a very honorable person. This is not something you would like to give up early. Moreover, only the best lawyers are chosen as judges. Only the very best. It's a very hard competition to become a judge. You can become a judge young, 30 years old, 32 years old. Not like in the common law system where you must already be an old guy. But you must be excellent. The judges are usually better than other lawyers. That plays an important role. The administrative judge usually has a better understanding of administrative law than the lawyers in public administration. That all plays a role, but then also it has developed a mentality, also because the public supported that. When we have judicial decisions on controversial topics, of course, a part of the population will be against that decision of the court. If the court decides the other way around, another part of the publication, the people will be against it. So it's important that the court shows that it works professionally and is independent. The last aspect is the courts are controlled too in a soft way, but painful way. You know by whom? By the legal scholars. So it is the job of the law professors, of the law students, to the young lecturers in particular, the doctoral students, to analyze the jurisprudence of the court. So this happens in Indonesia too. Yes, I read, for example, critical analysis of decisions of the Supreme Court or of the Constitutional Court, but not in Indonesian. They are published abroad and in English language. In Germany, they are published in the German journals, and they have a very high influence also. If the judge does not show a profound, scientifically based reasoning in his judgment, it can happen that his judgment will be torn apart. It happens even with some constitutional judgments where I show my students in the course, this is exactly what you must not do. If you do it like the Constitutional Court in this decision, you fail even the beginner's exam. That has an impact. So the jurisprudence is much more continuous. If the judge wants to decide differently than the courts have decided before, there need to be good reasons, because all lawyers will talk about, why has he decided different now? This, for example, hinders corruption. If the judge is corrupt, he must decide not in line with the old jurisprudence, but he must decide in line with the interests of the person who has bribed him. And maybe in the next case, that can be adversary interest. So in the next case, he may take a decision which is inconsistent with the decision in his previous case. In Germany, the scholars would tear that apart, and it would get the prosecutor even suspicious on what is happening there. So you need this legal culture. Jurisprudence is not alone. They are independent, but they also get the criticism from the highly qualified legal scholars and from the practitioners too. This is all a huge debate. And once you have this huge debate, it's much more difficult to be corrupt. But also, the judges, they see that the people, the population, they honor it if the judge is independent and the judge shows his independence, cannot be put under pressure. The people honor that. So this is considered as the role of the judiciary under the separation of powers. If you have a separation of powers following the model of Montesquieu, it is the role of the judges not to be soft, to be tough with the executive. Okay, I hope that answers your question.
Thank you very much for your answer.
Okay, thank you Sobihul for giving Prof. Thomas the interesting question. Yeah. So yeah, what can I conclude about your question is that the system in Germany and Indonesia is pretty different. Yeah, bro. Even the one in the East Europe is also different from the western part of Europe, and also the judges there in Germany cannot be influenced by any political interest because they're really independent and they have their own good integrity to be the judges. Okay. Yeah. So, is there any other question? We still have time. We will give time for that part. Yeah.
Good morning, Prof. My name is Ayuni. I want to ask you, what if a rule that has been established and enforced for a long time is then given a judicial review place? Because, of course, this will have a major impact or change on law enforcement. Thank you.
Could you please repeat your question?
Repeat, sorry.
But
Okay.
slowly, yeah.
What if a rule that has been established and enforced for a long time is then given a judicial review place? Because, of course, this will have a major impact or change on law enforcement.
A judicial review of the law? Yes. Yeah. Yes. It's not.
Let me read this in Indonesian and let me translate into English ya. The Indonesian one is bagaimana jika suatu peraturan yang sudah lama dibentuk dan diberlakukan kemudian diberikan kebijakan judicial review karena tentunya hal ini akan berdampak besar atau perubahan terhadap penegakan hukum. Okay, so she's asking what will happen if a kind of regulation that has been established long time ago and then another external parties bring this issue to be done the judicial review by the constitutional court and considering the consequences that it will give a very big impact on the society and the government. Thank you, Prof.
Yes, thank you very much. That is indeed a difficult question in practice. We have in Germany, under this application for judicial review of sub-legislative legal provision, what I showed, part 5.7, we have 1 year deadline. So 1 year, the citizen have the possibility to attack a sub-legislative regulation under this legal remedy. After that, it's finished. That is indeed a problem, but there are also legal remedies before the Constitutional Court on the land level and before the Federal Constitutional Court. So if that legal regulation is very old already and it violates the rights of the citizen, a fundamental right, then it can be brought before the Constitutional Court, and it would be the Constitutional Court who decides about that. That can also still be done in the form of constitutional complaint by the citizen himself, in an individual constitutional complaint. There is one principle that is clear: a human rights violation, a fundamental rights violation, can never be accepted. There is no deadline. So it can be brought before the Constitutional Court, but only for this reason. If there are other reasons of illegality, there are limits. Does this answer your question? I would also answer very briefly to what you said. Very interesting, the differences with parts of East Europe, not whole East Europe. Ladies and gentlemen, in East Europe, in some countries, we still have corruption. I worked before in the Republic of Moldova, a small country next to Ukraine, and there the corruption of the courts was higher than in Indonesia. So there are still, in Russia, for example, or in Turkey, the judges just follow the orders of the president. So the president office gives directly orders how to judge on the cases. But also in the European Union, we have two countries. I'm very sad that I need to talk about that. We have two countries which have member states which have left the path of the rule of law. One is Hungary and one is Poland, which, however, is under pressure now. These countries have destroyed the independence of judges. In Poland, they have made a law which controls an institution which is controlled by the government to control the judges. And judges who have taken decision against the Polish government have been dismissed. So this is a huge problem. Poland at the moment is not a state based on the rule of law anymore. And there are sanctions taken against Poland, but Poland, the same with Hungary, should not be a member of the European Union anymore. Because European Union says every member state must be committed to democracy, human rights, and rule of law. We see such dirty tricks to establish commissions to control, disciplinary commissions to control judges in several countries. If this happens, you need to be really careful if this commission can be controlled by the government or the president, or if the parliament or the president can just send some buddies to these commissions who are close friends of them. That is also the second element what they try in Europe. For example, in Poland, they did this with the Constitutional Court. They changed the law, and then, because of a political constellation which allowed it, they chose only close friends of the new government as constitutional judges, who had no qualification at all. If this happens, and we see that in several European countries, the whole system breaks down. In the Republic of Moldova, where I worked before, there was even, but not when I was there, I was already working here in 2019, a coup d'etat against the lawfully elected new government made by the Constitutional Court. The Constitutional Court itself started a coup d'etat and declared the election of the new government for illegal, although there was no reason for that at all. And finally, there was a big conflict, and finally it was USA Russia and European Union and the Council of Europe and expert committees who said this is just a coup d'etat, this is not jurisdiction anymore, jurisprudence. How could this happen? The country had been controlled by an oligarch who was able to place 2 or 3 close friends of him, who were lawyers but not qualified, as constitutional judges. And they just followed his orders. So, you need to have the independence of the judges. And it must be defended already against the first steps of trying to control them. Otherwise, the whole system will not work reliably. Thank you.
All right, thank you. Let's give applause to Prof. Smith for the explanation. Yeah, it's really interesting that also for most of us, our greatest fear is that the judges will not be independent any longer, because it's really dangerous that they cannot make any balance in the system of the government. So we hope that what happened to Moldova and other countries that has a really high rate of corruption will not happen here in Indonesia. That's why Professor Smith, our students here in Indonesia, they really have critical thinking, so they always monitor any update happening in the Indonesian society, just like the current case happening to the former chief of Indonesian general, that every people are really monitoring. They even stay on the screen to see what final verdict that finally the judge give to the person. Yeah?
Good, yeah.
Okay, well, so time flies, yeah, bro, because we really have a fruitful discussion, and in fact, it's more interesting when we can discuss, yeah, two ways communication. So we can gain something new from Professor Smith, and also Prof. Smith can also get something new, yeah, ideas from students of Universitas Muhammadiyah Purwokerto, particularly the Faculty of Law, that are really critical. They have really critical thinking skills.
Good.
Okay, well, so once again, let's give applause to Prof. Smith for delivering a very fruitful presentation to us. We really appreciate your participation to this discussion. Yeah. 3 questions are not enough, actually. We see that there are more students who want to ask questions.
Everybody is invited to contact me. When you go on my website, there is my contact address. Anybody who has questions, lecturer or student, don't be shy, right? And in the worst case, I'm also able to translate from Bahasa Indonesia.
Yeah, so Prof. Smith already invited you to contact him directly, because it's already stated, sudah ada di websitenya Prof. Smith, bisa dicari di Google, Profesor Thomas Smith, ya, akan muncul website beliau, dan ada juga kontak person di bagian bawah. Nah, nanti boleh mengontak untuk mengundang barangkali di acara kemahasiswaan ataupun mengundang langsung untuk perkuliahan di Fakultas Hukum, begitu. Okay, thank you very much for the time, Prof. Smith, and really appreciate your coming and also your time here. And hopefully we can have another agenda that we possibly invite you in that event. Okay, Professor Smith. So we're coming to the end of. Yeah, let's give another applause to him. All right, so we're coming to the end of the second session of presentation, and right after this, we still have another speaker from our beloved university, Dr. Indriati Amarini, who will be speaking about the judicial review policy here in Indonesia. Okay, so. All right, ladies and gentlemen, we're going to the third speaker's presentation, but in this occasion, my colleague from International Office will continue my job to be the moderator, and yeah, I think he's already well prepared, yeah, over there. And please come to the stage, Mr. Mahdi. Let's give applause to him, by the way. Okay, so thank you very much for your attentions, and I really appreciate your attention during this seminar, and I will give the session to Mr. Mahdi. Thank you.
Thanks a lot to Mr. Novan Andrianto for giving me this opportunity. Assalamualaikum warahmatullahi wabarakatuh. May peace and prosperity be upon all of us. Ladies and gentlemen, the audience of this international seminar, we have reached to the final section of this event. Our previous honorable speakers have already discussed about the judicial review policy in Malaysia and Germany. Now it is the turn to talk about Indonesian judicial review policy. And as the last speaker, we have Dr. Indriati Amarini. And we are so privileged for having her as the speaker, since her expertise on that particular topic is undisputable. Beforehand, I would like to read some part of her curriculum vitae. Dr. Indriati Amarini has finished his doctoral degree in Universitas Negeri 11 Maret, Surakarta in 2016. She is the Vice Dean of Faculty of Law, Universitas Muhammadiyah Purwokerto, and the Senior Lecturer of State Administrative Law concentration. Besides that, she is also one of the most productive author in Universitas Muhammadiyah Purwokerto. Without further ado, Dr. Indriati Amarini, for the next 30 minutes, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Permission for presentation in Indonesia, ya, karena ini versi Indonesia. Jadi mohon izin saya menyampaikan presentasi pakai bahasa Indonesia. Ya, mudah-mudahan bisa dipahami dengan baik. Judul yang saya ambil karena ini juga bagian dari bahasan dari Prof. Thomas, yaitu terkait dengan Judicial Control of Public Administration in Indonesia. Jadi karena ada perbedaan, tadi juga disampaikan ada perbedaan latar belakang budaya dan sebagainya, begitu. Bahasan saya terkait dengan lembaga pengadilan administrasi negara. Kalau di Indonesia menggunakan istilah yang digunakan adalah pengadilan tata usaha negara. Jadi ada beberapa landasan filosofis terkait dengan keberadaan, ya, lembaga pengadilan tata usaha negara. Bisa dilanjutkan di next. Jadi yang pertama adalah konsep negara hukum kalau di Indonesia, jadi negara hukum Pancasila, kemudian keadilan sosial dan kedudukan yang sama di depan hukum atau equality before the law. Yang pertama terkait dengan negara hukum Pancasila yang merupakan dasar moral, ya. Bagi tertib hukum di Indonesia ada beberapa poin di situ. Yang pertama, ketuhanan yang Maha Esa. Ini bisa dilihat di putusan pengadilan juga ada irah-irah, ya, berdasarkan keadilan berdasarkan ketuhanan yang Maha Esa. Kemudian keserasian hubungan antara pemerintah dan rakyat berdasarkan asas kerukunan. Kemudian yang ketiga, hubungan fungsional yang proporsional antara kekuasaan negara. Yang keempat, terkait dengan prinsip musyawarah mufakat. Dan yang kelima, di sini pengadilan menjadi sarana mewujudkan seimbangan antara hak dan kewajiban. Selanjutnya terkait dengan keadilan sosial, karena penegakan hukum pengadilan tata usaha negara di sini tujuannya, goalnya adalah mewujudkan keadilan sosial. Jadi keadilan sosial di sini seperti apa? Yaitu adanya keseimbangan kepentingan pribadi atau individual interest dengan kepentingan umum atau kepentingan bersama. Jadi bagaimana pengadilan administrasi negara di sini bisa mewujudkan keadilan sosial. Jadi kalau ini mahasiswa Fakultas Hukum pasti tidak asing dengan yang nama timbangan begitu ya, timbangan lambang keadilan. Di situ harus ada kesesuaian antara kepentingan individu dan kepentingan umum atau kepentingan bersama. Nah ini yang menjadi PR ya, agak susah untuk mewujudkan tersebut. Jadi harus seimbang. Selanjutnya terkait dengan prinsip kedudukan yang sama di depan hukum. Yang poinnya di sini adalah semuanya, baik masyarakat maupun pemerintah dalam hal ini, penguasa begitu, harus mempunyai kedudukan yang sama. Apabila melanggar hukum, ya harus bisa diproses di lembaga pengadilan. Oleh karena itu, ya, karena syarat suatu negara hukum di situ harus adanya lembaga pengadilan administrasi negara, maka dibentuklah lembaga pengadilan administrasi negara. Namun berbeda juga ya, kalau di dalam beberapa sistem tadi yang seperti disampaikan di Malaysia, di Jerman, dan di Indonesia gitu. Kalau pemerintah dalam hal ini melanggar hukum, dibawanya ke lembaga pengadilan administrasi negara. Jadi dibedakan antara masyarakat dengan pemerintah. Jadi ada lembaga pengadilan tersendiri. Ya. Ini bisa dilihat di konstitusi di Indonesia. Kemudian terkait dengan pengawasan administrasi publik, judicial control dari administrasi publik. Nah, di Indonesia ini ada dua hal atau dua langkah begitu ya, bisa diajukan ke lembaga pengadilan atau juga bisa diajukan ke atau non litigasi. Nah, ini pun juga berbeda-beda, lembaganya juga berbeda. Kalau yang non litigasi ini ada yang namanya bisa disampaikan ke lembaga ombudsman, ya. Kemudian bisa juga dilakukan melalui penyelesaian di lingkungan pemerintahan sendiri. Ya, jadi melalui lembaga pengadilan atau yang non litigasi bisa melalui ombudsman dan penyelesaian di lingkungan sendiri yang namanya upaya administratif dan banding administratif. Jadi berbeda-beda untuk lembaganya. Kemudian selanjutnya terkait dengan pengadilan tata usaha negara atau pengadilan administrasi. Jadi kalau ditanyakan apakah di Indonesia ada pengadilan administrasi? Ada, karena di dalam Undang-Undang Nomor 5 Tahun 86 disamakan. Pengadilan administrasi adalah pengadilan tata usaha negara. Nah, ini ada sejarahnya mengapa menggunakan istilah tata usaha negara. Karena pada awal pembentukan lembaga pengadilan tata usaha negara, jadi kalau kita lihat di dalam Undang-Undang Nomor 5 Tahun 86 ini hasil dari kompromi sebenarnya ya, kompromi politik di lembaga antara pemerintah dan DPR. Karena kalau dilihat dari sejarahnya di situ, ini membutuhkan waktu yang lama karena menggugat pemerintah adalah sesuatu yang mustahil pada zamannya, pada tahun 70. Jadi kekuasaan pemerintah sangat besar sekali. Kita kenal dengan zaman Orde Baru, ya, dengan kekuasaan yang sangat otoriter, agak sulit untuk membuat lembaga pengadilan di mana yang digugat adalah pemerintah. Jadi undang-undangnya sendiri sebenarnya ada di dalam Undang-Undang Nomor 14 tahun 70-an. Sudah ada lembaganya. Kemudian undang-undangnya baru ada di tahun 86 dengan keluarnya Undang-Undang Nomor 5 tahun 86. Ini kurun waktu yang lama. Mengapa? Karena kondisinya memang seperti itu. Agak susah untuk menggugat yang namanya pemerintah. Kemudian lembaga pengadilan tata usaha negara baru ada di tahun 91 dengan berdirinya 3 lembaga pengadilan tata usaha negara di beberapa kota besar saja. Ya. Kemudian selanjutnya di tahun 2004 karena ada penyatu atapan antara Mahkamah Agung dengan Departemen Kehakiman, ya, ini dalam konteks tadi independensi hakim, ya, maka di amandemen Undang-Undang Nomor 5 Tahun 86 itu amandemen pertama. Kemudian selanjutnya di tahun 2009 ini juga diamandemen lagi, ya. Mengapa? Karena salah satu permasalahan muncul di dalam Undang-Undang Nomor 5 Tahun 86 itu salah satunya adalah terkait dengan eksekusi. Jadi eksekusi putusan pengadilan sangat sulit dilakukan karena menurut hasil penelitian sekitar tahun 90-an itu 80% pejabat yang dikalahkan di pengadilan tata usaha negara tidak melaksanakan putusan pengadilan yang kemudian diamandemen dengan adanya upaya paksa. Jadi ada beberapa penambahan di ketentuan terkait dengan upaya paksa. Nah, selanjutnya di tahun 2014 ada dikeluarkan undang-undang tentang administrasi pemerintahan. Nah, di sini karena kalau dilihat di dalam kompetensi kewenangan pengadilan tata usaha negara itu ada beberapa yang menjadi bukan kewenangannya. Contohnya terkait dengan ketenagakerjaan. Kemudian tentang pajak itu kan dikeluarkan dari kompetensi pengadilan tata usaha negara yang kemudian kewenangannya menjadi sangat sempit. Oleh karena itu diperluas dengan adanya undang-undang tentang administrasi pemerintahan. Jadi ada perluasan bahwa pemerintah dapat digugat, pemerintah dalam hal ini badan atau pejabat tata usaha negara, ya, dapat digugat karena adanya perbuatan faktual, ya, karena sebelumnya itu kan hanya yang bersifat tertulis saja, yang bersifat tertulis itu kan surat keputusan, ya. Jadi ada pembedaan. Kalau ke awal tadi ada perbedaan antara peraturan dengan keputusan. Kalau peraturan judicial review, nah ini maknanya judicial review, itu ke Mahkamah Konstitusi. Kalau ada suatu undang-undang bertentangan dengan konstitusi, kewenangan Mahkamah Konstitusi, sedangkan yang undang-undang di bawah, ya, ini menjadi kewenangan Mahkamah Agung. Walaupun ada wacana juga terkait dengan uji material peraturan perundang-undangan, kenapa tidak menjadi kewenangan Mahkamah Konstitusi? Ya, biar Mahkamah Agung di sini tidak terlalu banyak urusannya, karena mengurusi pengadilan di seluruh Indonesia, pengadilan di bawahnya. Itu wacananya seperti itu. Ya. Nah, kemudian yang tadi dari 2014 jadi ada perluasan. Bahkan sebenarnya di dalam undang-undang terkait dengan cipta kerja pun ada, misalnya kalau objeknya ya, objek di Pengadilan Tata Usaha Negara itu adalah keputusan tata usaha negara yang positif dikeluarkan. Nah, kemudian ada yang negatif atau fiktif. Jadi dengan tidak mengeluarkan keputusan pun itu disamakan dengan mengeluarkan keputusan yang berarti menolak. Jadi diamnya seorang pejabat itu bisa dibuka di Pengadilan Tata Usaha Negara. Kemudian ditambah lagi terkait dengan keputusan yang negatif positif. Jadi apabila mengajukan suatu permohonan dan pemerintah diam saja dalam jangka waktu 5 hari kerja, maka dianggap disetujui. Namun ini bukan kompetensi Pengadilan Tata Usaha Negara menurut Kamar Tun di Mahkamah Agung. Ini menjadi kewenangan eksklusif dari pemerintah ya untuk mengeluarkan surat keputusan. Itu sejarahnya yang cukup panjang memang. Jadi baru di tahun 86 ya, karena tadi kekuasaan pemerintah itu sangat besar sekali dan kemungkinan kecil kalau itu digugat di pengadilan akan menang begitu ya. Walaupun ada beberapa kasus waktu itu yang ramai terkait dengan kasus di mana pemerintah digugat oleh majalah Tempo ya, yang kemudian Hakim Benyamin Mangkudilaga memutuskan jadi Temponya di sini dimenangkan di proses Pengadilan Tata Usaha Negara. Namun dibandingnya dinyatakan kalah. Ya. Tetapi ini merupakan salah satu usaha bahwa tidak sesuatu yang kalau sekarang kan menjadi wajar ya dan sudah biasa kalau itu menggugat presiden atau pemerintah begitu di dalam proses Pengadilan Tata Usaha Negara. Selanjutnya, jadi hasil rumusan Undang-Undang Pengadilan Tata Usaha Negara dilihat dari perjalanannya tadi ada beberapa catatan sebenarnya. Yang pertama objek sengketa. Ini kan kalau undang-undang kan hasil kompromi ya, hasil kompromi antara pemerintah dan lembaga DPR. Jadi objek sengketanya sempit, namun ini di dalam perkembangannya juga diperluas dengan adanya Undang-Undang Nomor 1430. Jadi perbuatan faktual pun bisa digugat di Pengadilan Tata Usaha Negara. Kemudian yang kedua terkait dengan dismissal proses ya. Jadi ada proses-proses secara administrasi. Kalau di dalam hukum acara PT UN di sini sebenarnya untuk memilah apakah ini merupakan objek Pengadilan Tata Usaha Negara atau tidak. Karena pada awal pembentukannya ini ada kekhawatiran banyak sekali yang menggugat pemerintah begitu, dan ternyata tidak. Ya. Kemudian yang ketiga, pemeriksaan persiapan. Mengapa dibuat atau diadakan pemeriksaan persiapan? Karena di sini ada ketidakseimbangan antara kedudukan antara masyarakat yang menggugat dengan pemerintah. Ya, kalau masyarakat menggugat pemerintah, ini kan kedudukannya tidak seimbang. Oleh karena itu diadakanlah pemeriksaan persiapan. Kemudian yang keempat di sini Hakim Pengadilan Tata Usaha Negara bersifat aktif. Ya, mengapa dibuat ya hakim aktif? Karena itu tadi kedudukan antara para pihak yang tidak seimbang antara penggugat dan tergugat. Selanjutnya, yang terakhir, ini merupakan pedoman bagi pejabat publik di Indonesia. Jadi nanti mahasiswa di sini harapannya menjadi pejabat publik gitu ya. Nah, ini mengambil dari bahasa Jerman mungkin ya. Jadi pemimpin yang menguasai ini nanti Bapak Dalang ya yang nanti akan menjelaskan secara rinci begitu ya. Jadi pemimpin yang menguasai ilmu hastabrata yaitu pemimpin yang memiliki sifat alam yang mewakili simbol kearifan dan kebesaran Sang Pencipta, yaitu sifat bumi, sifat matahari, sifat bulan, sifat samudera, sifat bintang, sifat angin, sifat api, dan sifat air. Nah, dari hastabrata tersebut kemudian oleh Ki Hajar Dewantara disarikan dalam 3 kepemimpinan, yaitu ini sering kita dengar, Ingarso Suntulodo Ingmatyo Manginkarso Tutwuri Handayamun. Makaten lajeng yang terakhir hadis riwayat Al-Bukhari. Di sini setiap kalian adalah pemimpin dan setiap kalian adalah dimintai pertanggungjawaban. Seorang imam adalah pemimpin dan akan dimintai pertanggungjawabannya. Seorang laki-laki adalah pemimpin atas keluarganya dan ia akan dimintai pertanggungjawabannya. Seorang wanita adalah pemimpin atas rumah suaminya dan ia pun akan dimintai pertanggungjawabannya. Seorang budak juga pemimpin atas harta tuannya dan ia juga akan dimintai pertanggungjawabannya. Sungguh setiap kalian adalah pemimpin dan setiap kalian akan dimintai pertanggungjawabannya. Sekian, wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Dr. Indriati Amarini, for giving the comprehensive knowledge about the judicial control through state administrative court, which is the state of administrative court has been established for a long time ago, but around 70s, but it is only effective. After the end of the new order, the end of the Suharto's era. And we are heading to the question and answer session. We will give 3 opportunities. We will give the opportunity to 3 people who have question about this topic. And anyone who are willing to ask, then please raise your hand, stand up, and introduce yourself briefly. Please, if you have a question. We will wait for it. Okay, the audience of the seminar, we will wait for 5 minutes. If there is no question, then we will close the session. or maybe from the board of lecturers? Oh, from the middle. So, okay, we will go for the first questioner. Please introduce yourself briefly.
Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Perkenalkan, nama saya Aris Setiawan dari Prodi Ilmu Hukum semester 6. Izin bertanya, Bu, seberapa efektif judicial control di Indonesia? Mungkin sekian, terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thanks for the first questioner for this.
Jadi seberapa efektif judicial control administrasi publik ya di Indonesia? Kalau kita lihat terkait dengan judicial control, sebenarnya ada langkah-langkah ya yang bisa diambil oleh masyarakat apabila ada maladministrasi yang dilakukan oleh badan atau pejabat tata usaha negara. Yang pertama, bisa dilakukan melalui lembaga yang namanya pengadilan tata usaha negara atau pengadilan administrasi negara. Itu yang pertama, atau melalui lembaga pengadilan. Atau bisa juga dilakukan melalui lembaga ombudsman yang bukan merupakan lembaga pengadilan. Kalau lembaga pengadilan itu kan adalah lembaga yang memang independen. Tadi sudah disampaikan yang terkait dengan independensi hakim. Ya, kalau berbicara independensi hakim, saya sering melanggar independensi hakim. Karena kalau anak saya pulang, saya suruh potong rambut, dirapiin rambutnya, bilangnya melanggar independensi hakim. Seperti itu. Alasannya tidak penting itu penampilan, walaupun rambutnya panjang. Itu sesuatu yang lain hal ya. Oke, jadi bisa melalui langkah pengadilan yang namanya pengadilan tata usaha negara, kemudian bisa melalui lembaga yang namanya Ombudsman Republik Indonesia, bisa juga melalui atau diselesaikan melalui upaya administratif yang berada di lingkungan pemerintahan sendiri. Jadi kalau langkah-langkah itu biasanya dilakukan seperti itu. Jadi menempuh melalui pengadilan, kemudian bisa melaporkan ya, caranya melaporkan ke lembaga yang namanya ombudsman atau yang di lingkungan pemerintahan sendiri. Begitu.
Okay, thanks for Dr. Indri, and we will move to the second questioner. Stand up, please stand up.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Perkenalkan, saya juga Ilan Syahrinwan, mahasiswa semester 6 Ilmu Hukum UMP. Izin bertanya kepada Bu Indri, tadi dijelaskan terkait prinsip kedudukan yang sama di depan hukum pada pasal 27 ayat 1 segala warga negara bersamaan kedudukannya di dalam hukum dan pemerintahan dan wajib menjunjung hukum dan pemerintahan itu dengan tidak ada kecualinya. Pertanyaannya, bagaimana dari anggapan Ibu Indri terkait anggapan hukum tajam ke bawah dan tumpul ke atas, yang seakan-akan itu bukan hanya slogan belaka, melainkan benar adanya dalam menggambarkan sistem peradilan di Indonesia. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Ya, dalam konteks pengadilan administrasi ya. Nah, kalau di dalam pengadilan administrasi negara dibuat ya sebenarnya untuk adanya equality before the law. Karena apa? Ternyata pemerintah yang melanggar hukum atau istilahnya badan atau pejabat tata usaha negara pun bisa digugat di pengadilan. Begitu. Jadi adanya keberadaan lembaga administrasi negara itu tadi ya. Jadi siapapun yang melanggar hukum, baik warga negara maupun pemerintah di sini, apabila melanggar hukum bisa dibawa ke pengadilan. Namun dalam konteks administrasi tadi, dibawa ke pengadilannya adalah pengadilan tata usaha negara. Nah, sebelum lahirnya pengadilan tata usaha negara kemana? Ke pengadilan umum dengan dasar perbuatan melawan hukum. Namun ini dibuat pengadilan tersendiri. Jadi kalau ada pelanggaran hukum yang dilakukan oleh pemerintah atau badan atau pejabat tata usaha negara, tempatnya di pengadilan tata usaha negara. Begitu.
And we will move to the third and the last questioner. Please stand up.
Baik. Sebelumnya, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
warahmatullahi wabarakatuh.
Kenalkan, nama saya Yusmita Sari, mahasiswa semester 6 Prodi Ilmu Hukum. Izin bertanya kepada Ibu Indri, apakah perbedaan dari judicial review dengan hak uji material? Begitu. Terima kasih.
Ya, jadi judicial review. Nah, di kita ini memang lembaganya berbeda, tidak seperti dalam konsep di Malaysia dengan di Jerman tadi ya. Kalau uji materi ini untuk mengistilahkan judicial review. Jadi kalau terkait dengan adanya ketidaksesuaian ya di dalam peraturan perundang-undangan, ya, kalau ada undang-undang yang tidak sesuai, dianggap tidak sesuai dengan konstitusi, maka bisa diuji materialkan ke lembaga Mahkamah Konstitusi. Kewenangan dari Mahkamah Konstitusi. Namun kalau itu di bawah undang-undang, ya, peraturan pemerintah, peraturan daerah dan sebagainya, gitu, di judicial review-nya atau uji materialnya adalah di lembaga Mahkamah Agung. Gitu.
So, thank you for all of the questionnaires, and for sure also I would like to send my highest appreciation to Dr. Indriati Amarini for delivering this presentation with comprehensive knowledge. And we are coming to the end of this international seminar. The highest appreciation are given to to everyone for the attention and participation. And I would like to send my deepest apology if there are a lot of convenience in this seminar, especially in my session. And before it, I would like to invite the audience to give applause to Dr. Indriati Amarini. Thank you. Back to the master of the ceremony. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to the moderators for leading the sessions. Thank you so much for the speakers for sharing your expertise. I'm sure that everyone here feels so enlightened. Thank you to all participants. I believe you got the inspiration on how judicial review policy works in Indonesia, Germany, and Malaysia. Thank you for your participation. To all committers, thanks so much for giving the best for the hard work. Thanks you all. Let's close today's international seminar by reciting Hamdalah together. The last I say you, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Foto. Okay, could I get your attention, students? Kita bisa foto bersama dulu ya, antara mahasiswa dengan para dosen dari EVA dan juga Prof. Smith dan juga panitia. Silakan menempatkan diri, boleh ada yang di bawah, nanti ada juga yang naik ke stage.
Ya, silakan untuk panitia dan segenap para dosen untuk foto bersama mahasiswa. Jangan lupa nanti ada presensi MPPH dan pidana, kriminologi. Ya. Panggil dulu.